is an appeal in the matter of the King on the application of O'Brien, HM Assistant Coroner for Sefton, Knowsley and St Helens.
Understand.
Your Lordships, Your Ladyship, I represent the appellant in this matter. Mr Brown, King's Counsel, and Mr Illingworth appear on behalf of the Respondent, His Majesty's Assistant Coroner for Sefton, Knowsley and St Helens. Mr Cohen appears for the interested party, the Chief Constable of Merseyside Police. This, by way of an introduction, is an appeal against an order of His Honour Judge Sefton, King's Counsel, dated the 21st of February, dismissing the appellant's claim for judicial review. The underlying claim is one of judicial review of a decision of the Respondent in the ongoing coronial investigation into the death of the appellant's sister, Linda O'Brien, on the 9th of May 2020.
You can take quite a lot as read because obviously we have pre-read the materials.
I'm grateful, my Lord. May I begin then by, as I did in the court below, by drawing the focus of the court to the person who is at the heart of this case, that is Linda O'Brien. Linda died nearly 6 years ago now, at the age of 49 years, after coming out of the window of her flat and falling to the ground below. She's mourned by her family and friends, including her children and her sister Sharon, the appellant. The appellant is unable to be at court today, but is watching the live stream, my Lord. Her aim and that of her family is to secure justice for her sister by obtaining the fullest possible investigation into her death. And while the submissions before your Lordships and your Ladyship will of course focus on the legal arguments, those arguments must, in my respectful submission, be set in their proper context of what this case ultimately is about. That context also includes the fact that Linda was a known victim of domestic abuse. She was found at post-mortem to have fresh injuries not attributable to the fall from height. The perpetrator of that domestic abuse was with her on the night that she died, in breach of a restraining order against him. The fact that the restraining order was not enforced in the month before Linda's death should be a matter of acute concern in my submission, not just to Linda's family, but to the Respondent, to the first interested party, and to the wider public. The consequences of the non-enforcement of the restraining order in the weeks before Linda's death, in my submission, should be considered and investigated as part of a full and fearless investigation into Linda's death, both for Linda and to ensure that this doesn't happen again. And my overarching submission on behalf of the appellant is that both the Respondent and the court below have erred in law in determining that investigation into those matters can properly be excluded from the inquest at this stage. My Lord, I was intending to take you to the underlying facts which underpin this appeal. I note and take account of your Lordship's indication that you have, I can take that shortly, perhaps is the best way of putting it. But can I just take you through some of the significant matters in my respectful submission, which again form the background of this appeal. Key to this case is Linda's relationship with the second interested party in the judicial review proceedings, Mr McMahon. The appellant has not been provided with all details known in respect to this relationship, and that is a point to which I will return, Lord. But we know, as I've set out at the outset, that there was a history of domestic abuse involving Linda going back to 2017. And the Respondent tells us that there were 6 recorded incidents between Linda and Mr. McMahon, in which he was the perpetrator and she the aggrieved. 2 restraining orders have been imposed upon Mr. McMahon, both prohibiting contact with Linda. The first having been made on the 14th of December 2017, lasted until the 13th of June 2019. The second imposed less than 3 months after the first, on the 1st of September 2019, and that was due to last for 5 years. As your lordships, your ladyship are aware, that was still in force at the time of Linda's death. Merseyside Police came into contact with Linda around a month before her death. On the 7th of April, Linda's friend and neighbour, Anthony Larkin, called 999 anonymously to report that he had heard her screaming, and he rang 999. Lord, his police statement is within the supplementary bundle at page 126, but it's clear from that he told...
Meaning you would like us to look at it?
My Lord, I don't think it needs to be turned up. I just
yes.
Give you the reference for your lordship's note. But significantly, he made a report of Linda screaming, shouting, "Help me," and "Get off." He rang 999. And that was the call which led to the attendance of 4 police officers at Linda's address that night, who spoke with Linda and with Mr. McMahon, who was present at the flat. Your lordships are aware that the officers were aware during the course of that encounter, during the course of their visit to the flat, that Linda was a so-called gold domestic violence victim. So that was information that was known to the officers, but none of them became aware of the extant restraining order, despite the involvement of a number of civilian officers and police officers who conducted various checks. Mr. McMahon, as you know, was not arrested for breach of the restraining order. All 4 officers said that if they had known about that order, they would have arrested Mr. McMahon at the scene. As it was, Mr. McMahon left the property before the officers, and a series of steps were required to be taken by the officers in pursuance of the first interested party's domestic abuse policy, those being essentially risk assessments of different types. Those steps were completed by one of the officers, PC Judge, after they had left Linda, rather than in her presence, as was required by the relevant policy. And the upshot of that was that Linda was not asked directly about the existence of the restraining order, and the order's existence and breach of it were not identified at that stage. That happened later, when another police officer, PC Wood, was doing follow-up on a previous offence or an alleged offence against Linda, and it came to his attention that the police had seen Mr. McMahon at the property on the 7th of April in breach of the restraining order. So he sought advice about what to do about that, set in train inquiries to obtain a statement, to investigate the breach as a crime, and those inquiries were still ongoing at the time of Linda's death. As your lordships, your ladyship will have seen, there was a call by Mr. McMahon on the 9th of May 2020, 3:03 a.m, following which paramedics attended and confirmed Linda's death at 3:12 in the morning. It seems that Mr. McMahon was the only person with Linda at the flat, or there's certainly no evidence that anybody else was there. A post-mortem examination was undertaken by Dr. Rogers, Home Office pathologist, on the day of Linda's death. And that examination concluded that the majority of Linda's injuries that were identified had been caused by the fall. That was his conclusion. But Dr. Rogers was concerned by other injuries which he identified. He noted that there were injuries to the right side of the face, which in his view would be consistent with assault injuries such as punches or slaps. There was also evidence at post-mortem that before exiting the window, Linda appeared to have been struck with a weapon to the left shoulder or arm area and the lower right shin or foot, consistent with a broken mop which had been found at the scene. It is relevant to note that a local shop worker, Miss Schuler, provided statements to the police in which she said that when she had seen Linda earlier that evening, she didn't have any facial injuries at all. My lord, Mr. McMahon was arrested at the scene on suspicion of murder in the event that was not proceeded with. But he was prosecuted for theft and multiple breaches of the restraining order. And he was sentenced the 19th of June 2020 to 20 months imprisonment. Importantly, and again, I'll return to this if I may, the appellant has not had any disclosure of Mr. McMahon's antecedents or previous convictions, and they haven't formed part of the submissions made on the appellant's behalf or of the decision making in this case.
So does that mean that the coroner did not know what Mr. McMahon's criminal record contained?
My lord, I don't know the answer to that. Mr. McMahon, as far as the appellant understands from the media reporting and of the sentencing in June 2020, had 35, the court was told at that stage that Mr. McMahon had 35 previous convictions for 60 offences, including offences of violence against Linda. The appellant, on behalf of the appellant, submissions have been made requesting disclosure, whether it be from the first interested party or should the coroner have that information from the coroner, to enable the appellant to make submissions which are relevant in my respectful submission to causation, which I'll come to later on. But those matters, those documents or that information has not been disclosed to the appellant. So she has her awareness in respect of Mr. McMahon's previous convictions and antecedent history comes from what she has been told by the police and what has come to light during the course of the criminal proceedings which post-dated Linda's death. Lord, after Linda's death, an IOPC investigation was conducted into the contact between Linda and Merseyside Police between the 7th of April and the 9th of May 2020. The IOPC decided that there was no indication of any matter which would justify disciplinary proceedings or criminal proceedings either. There were recommendations for practice requiring improvement advice for 2 officers in relation to their completion of one of the risk assessments required under the domestic abuse policy, the vulnerable person referral form. And there was also a recommendation that there should be learning by reflection for 2 members of staff within the control room. But as far as the appellant understands, the reason for the restraining order not coming to light or not being known to the officers on the 7th of April has not been established.
Was it ever established whether the restraining order was at the material time there to be seen on the PNC?
I don't believe that specific matter has been established, my lord. Again, the question of what is contained within the PNC record in respect of Mr. McMahon is information which the appellant submits is relevant for consideration at the inquest, and it's information which the appellant has sought disclosure of from the respondent. It hasn't, I don't know if it's been made available to the respondent, but it hasn't formed part of any disclosure to the appellant. And it's that in my respectful submission is a key piece of evidence which falls to be considered by the respondent, and it was information which was not before the High Court when making the decision, when making its ruling on the lawfulness of the respondent's conclusion on causation. And our submission is that those are really crucial pieces of evidence without which it was not possible to make a lawful decision as to the causative impact of the failure to enforce the restraining order.
And by lawful, does that mean rational in this context?
Yes. My lord, as you know, the respondents came to have conduct of the coronial investigation into Linda's death, it having been opened by the senior coroner in May 2020. The respondent received submissions from the interested persons in the inquest on various preliminary matters, including the engagement of the enhanced investigative obligation under Article 2 of the European Convention, the scope of the inquest, and whether a jury should be summoned to hear the inquest. And it was contended on the appellant's behalf, as it is before your lordships, your ladyship, that the inquest should investigate the attendance of the police on the 7th of April and subsequent events in connection with the restraining order between 7th of April and 9th of May. The respondent issued a decision notice and directions on the 15th of March 2023, which is the decision which is the subject of the judicial review proceedings, concluded that there was no requirement to hold the inquest of the jury, as on the evidence before the court, the death did not result from an act or omission of a police officer. And the decision notice went on to say this: in relation to my determining coronial causation between the events occurring on the 7th of April 2020 and 9th of May 2020, the standard of proof is on the balance of probabilities. Threshold of proof is that the events and police involvement on the 7th of April must have contributed more than minimally to the death on the 9th of May. The causation question is whether, on the balance of probabilities, the event or conduct in question more than minimally, negligibly or trivially contributed to the death, and the event or conduct on the 7th of April must make an actual and material contribution to the death of the deceased. The notice went on to say that, in my opinion, on the evidence before the court, there is no coronial causation established linking events involving police officers on the 7th of April to those events on the 9th of May resulting in the death. And then the decision went on to conclude that the scope of the inquest would focus on the events of the 8th and 9th of May in particular, that Mr. McMahon would be called to give evidence, and that the events of 7th of April and the restraining order would not require extensive investigation. Mention of such would be for background purposes and information. And as part of that, or connected with that, an indication was given that evidence would not be called from any of the police officers who attended on the 7th of April, or indeed from the officer who discovered the breach in the interim period. The decision, the written decision, doesn't give express reasons for the decision on scope, but it's evident from the notice read as a whole and from the conduct of these proceedings that the decision not to investigate the actions of Merseyside Police was underpinned by the decision on causation. And the causation decision is the key focus of challenge in the judicial review claim. My Lord, you've seen from the papers the procedural history of the judicial review claim, and I won't take you through that. The key issue, or the only issue before the court below, was whether the respondent had erred in law by prematurely and irrationally deciding that there is no causative connection between the acts and omissions of Merseyside Police and the death of Linda O'Brien, and thereby unlawfully limited the scope of the investigation. My Lord, I have set out a summary of what, in my respectful submission, are the key relevant legal principles at the appellant's skeleton argument at paragraph 24. I think I can deal with those legal principles relatively quickly. I don't think there's any material dispute between the parties, and they may well be familiar to your lordships or to your ladyship.
So certainly in my pre-reading, I haven't really detected any great difference on the legal analysis.
No. Thank you, Lord. Just to set the scene then, if I may, for the submissions, section 10 of the Coroners and Justice Act sets out the determinations and findings to be made in an inquest, and directs the reader to section 5 of the same act, at which the statutory questions, if I can put them like that, are set out. So the statutory questions to be answered by the coronial investigation are who the deceased was and how, when and where the deceased came by his or her death. The function of the inquest has been the subject of judicial commentary, and may I refer you to the case of Dove, in which your ladyship gave the judgment of this court, and that is at tab 15 within the authority
I
conduct.
don't think, at least I haven't got tabs. If you give me a page number.
Oh, I do apologise, my lord. It's 548. That's a PDF, so.
Yep. D403. Yes.
My lord, I don't intend to take you through the decision in Dove in any detail at all. The reason why I cite it is for Her Ladyship's description of the function of an inquest being which was reaffirmed as being to seek out as many of the facts concerning the death as the public interest requires, and to establish the substantial truth about the death, and that's at paragraph 72, Lord.
Sorry, page number again.
The page number is
That must be 420.
420.
72.
Paragraph 72, Milady, and it's the second sentence of that paragraph. It was where Your Ladyship came to consider in that case whether it was necessary or desirable in the interests of justice that there should be a fresh inquest into the death of Jodie Whiting. And during the course of your consideration of that question, Your Ladyship set out those principles as to the function of the inquest, looking back to the cases of Sutovich and the Hillsborough judgment.
So there's nothing new and done. There's no fresh ground being broken. It was just a summary of what had gone before.
Milady, yes, it's a reference back, as you say, to the established principles, which I would seek to rely on in this case, as setting the scene, if I can put it in that way, for the way that those statutory questions ought to be considered and applied.
That was a case where the chief coroner was submitting that the coroner should not, either could not or should not, inquire into the reasons why somebody might commit suicide. In other words, the discretion either was or should be limited.
Yes.
And really the upshot of the court was to say it isn't so limited.
Yes.
Coroners do have a very broad discretion to investigate in an appropriate case, which is a matter of discretion,
Yeah.
the reasons why deaths come to pass. It's not just always about the immediate the death itself. You can look a bit further if so
Yes.
minded.
So the point that I'm seeking to make, or to the submission that I'm seeking to make, is that there is public interest element to the coronial inquiry, which in my submission must operate to guide the coroner in the decision making on the scope of the investigation. My Lord, as to the investigative duty of the coroner, this is examined or touched upon at least in the Jameson case. So it's the Crown and Her Majesty's Coroner for North Humberside and Scunthorpe ex parte Jameson. This, my Lord, is at, I'm sorry, I just need to find the page because I have
Yes, you've been working by tabs.
333.
Yes.
Again, I just seek to draw from this case principle in respect of the conduct of the inquest, and the passage that I am I'd like to draw your ladyship's attention to is one which was cited by His Honour Judge Sefton King's Counsel in his judgment, and it describes the overarching duty of the coroner. So this was a case which concerned a death in custody, and it looked at principles of law in respect of the conclusion of neglect in inquest proceedings, but it also set out some general principles in respect of the conduct of the inquest. And may I invite your lordships to look at D58, please. And this is the 14th in a series of propositions that Lord Bingham had set out in respect of the coronial inquiry, various aspects thereof. And this is his encapsulation or his summary of the duty of the coroner, saying this: it's the duty of the coroner as the public official responsible for the conduct of inquests, whether he is sitting with a jury or without, to ensure that the relevant facts are fully, fairly and fearlessly investigated. He's bound to recognise the acute public concern rightly aroused where deaths occur in custody. He must ensure that the relevant facts are exposed to public scrutiny, particularly if there is evidence of foul play, abuse or inhumanity. He fails in his duty if his investigation is superficial, slipshod or perfunctory, but the responsibility is his. He must set the bounds of the inquiry. He must rule on the procedure to be followed. His decisions, like those of any other judicial officer, must be respected unless and until they are varied or overruled.
Now, you obviously stress the first sentence.
I do.
I think the interested party might stress the last bit. With the bit, with the bit in the middle, evidence of foul play, abuse or inhumanity.
Yes, my lord, I certainly stress the requirement for a full, fair and fearless investigation. And again, I would submit that that is the backdrop, if your lordship pleases, to the question of the application of those statutory questions, and indeed the backdrop to your ladyship's consideration of the rationality of causation decisions in this case. But I also emphasise the public concern point, which in this case related to deaths in custody, but in my submission is a point of wider application, and it's a point which is relevant to your lordship's consideration of the present case. And I also, if I may take up your lordship's suggestion, maybe putting it a bit too high, but the third sentence, again, emphasis there: he must ensure that the relevant facts are exposed to public scrutiny, particularly if there is evidence of foul play, abuse or inhumanity. And again, that sentence and the failure of duty where the investigation is superficial, slipshod or perfunctory, those being extreme adjectives, but in my respectful submission, draw the attention of the court or to the reader to the need to ensure that the coronial investigation is a robust one. And going back to the full, fair and fearless investigation point, it's about ensuring that relevant facts are fully, fairly and fearlessly investigated. So, of course, that begs the question in a particular case of what those relevant facts might be. But all of those considerations, in my respectful submission, call for attention in the present case. And so, as I think I said, my submission is that these observations provide the court with the framework within which this decision on scope is to be taken, and that decision has to have regard to those considerations that your lordships have just looked at, so that the investigation can, going back to that summary in the Dove case, establish as many of the facts concerning the death as the public interest requires, and establish the substantial truth. Just moving on to scope, my lord, we've just seen in that extract from Jameson that it's for the coroner. I, of course, accept that it's for the coroner to set the bounds of the inquiry, and that is a matter for her or him, subject to supervisory review by the higher courts. But in my respectful submission, we know from subsequent authorities, including Delalio, which is the one that I wanted to take you to next, that this does not unduly, in my submission, constrain the bounds of the inquiry. So the how. So perhaps I should start that again. My submission is that the inquiry is not unduly constrained by the statutory questions, including the question of how, which in Jameson inquests is to be understood as meaning by what means, rather than in what broad circumstances, as would be the case in an inquest where the Article 2 enhanced investigative obligation is engaged.
You're not challenging the Article 2 decision, are you?
I don't challenge the Article 2 decision in this claim. That, in my respectful submission, however, is a relevant consideration, because it's my submission that one matter or one potential consequence of the investigation that I contend for, that I submit is required to be done into the police actions and omissions in the month before Linda's death, is that it may be that such investigation would give rise to information which may suggest an arguable breach of Article 2.
Okay, but so can I just see if I play it back to you and see if
Yes.
I'm roughly in the right place? As things currently stand, we're in Jameson territory,
Yeah.
which is quite a flexible concept
Yes.
anyway. But it's entirely possible, you say, that if you did a proper Jameson disclosure analysis approach, you would come by evidence that suggested a real and immediate risk that wasn't acted on. So you might well be in Article 2 territory. We're not there yet.
That may be so, or indeed, milady, it may disclose information which suggests an arguable breach of the systemic duty under
Okay.
Article 2.
So not an Osmany type case, but a sort of systems breach type case.
I wouldn't either, milady.
Either or, okay.
If I can keep my options open, as it were, but in my respectful submission, either an arguable breach of either of those substantive duties, as your ladyship is aware, would be sufficient to engage the enhanced investigative obligation under Article 2. It may be there isn't. This case does not concern a challenge to the article decision at this point. However, in my respectful submission, and I think this was expressed initially by the senior coroner, perhaps not by the respondent, but it is incumbent upon any coroner to maintain the question of Article 2 under review at all stages throughout the investigative process. And so that is something which could potentially be brought to light by the investigative process, as your ladyship has indicated. But for present purposes, it's the Jameson concept, as your ladyship has indicated, which is before the court. The Delalio case, which I think I'm right in saying was heard just 2 months after Jameson, brought Lord Bingham back to the inquest context. My Lord, it's at D6. In fact, it comes before
So
Jameson.
it's reported earlier, but it decided later.
Yes. And this was the case, sorry, it's at D6, it's the beginning of the report, I believe. This case concerned the inquest into the deaths of the victims of the Marchioness disaster. And the issue was not one of scope directly as it is in this case, but whether the coroner's decision not to resume the inquests after the criminal proceedings was flawed on the ground of apparent bias and whether the inquest should be resumed. But I wanted to draw the court's attention to a couple of observations which were made in respect of the scope of the coronial inquiry. Firstly, Lord Justice Simon Brown, this is at D22 and it's 155B in the report, my Lord.
The way of these things, there's something for both sides.
Yes.
Yep.
Which bit are you after?
So the paragraph starts that of course, and it's the third sentence of that paragraph which says this: the inquiry is almost bound to stretch wider than is strictly required for the purposes of a verdict. How much wider is preeminently a matter for the coroner, whose rulings upon the question will only exceptionally be susceptible to judicial review. And so, as your lordship says, I would emphasise the beginning of that sentence, but obviously I recognise the second part of it is there too. What I would say, the submission that I would make in that respect, though, is that the oversight or the review by the High Court and indeed the supervisory role of this court is simply orthodox public law principles. In my submission, there isn't any test, any exceptionality threshold for the appellant or the claimant to overcome.
Public law principles obviously includes rationality,
Yes.
as you say, also taking into account wrong considerations.
Yes. The Lord Bingham's judgment in the same case is follows that of Lord Justice Simon Brown, and may I draw your attention please to D31. And the passage which I'd like to refer you to is the paragraph which starts secondly, just below E. So this is where this part of the judgment refers back to the recent decision in Jameson, and it goes on about halfway through the paragraph. eight lines down, Lord Bingham says Jameson's case was specifically directed to the verdict of lack of care in the context of deaths in custody, but the court's ruling was of wider application. And then the judgment goes on to talk about the application of those principles in the case under consideration, but then goes on to say this: the court did not, however, this being the court in Jameson, the court did not, however, rule that the investigation into the means by which the deceased came by his death should be limited to the last link in the chain of causation. That would not be consistent with the court's conclusion in Jameson, which emphasised the need for full, fair and fearless investigation and the exposure of relevant facts to public scrutiny. And it would defeat, says Lord Bingham, the purpose of holding inquests at all if the inquiry were to be circumscribed in the manner suggested. It's for the coroner conducting an inquest to decide on the facts of a given case at what point the chain of causation becomes too remote to form a proper part of his investigation. That question, potentially a very difficult question, is for him. So again, my lord, this is a passage which is cited by everybody probably in these proceedings, but I would emphasise the bits that your lordships, your ladyship might expect me to emphasise about the need not to circumscribe unduly the scope of the investigation, and also the emphasis on the fact that this isn't just looking at the last chain, the last link in a chain of causation. My lord, the final proposition that I wanted to draw from the authorities in respect of scope is one which I think is established from a number of authorities and been touched on in Dove, which is that a Jameson inquest is not narrow in its scope. And to illustrate that proposition, may I ask you to look at the report in Worthington, please, which is D320. And this case again was directed to a different question, which was the lawfulness of the matters recorded on the record of inquest in Poppy Worthington's case. But in dealing with that question, the court did touch upon the question of scope and cast its eye back on some of the authorities dealing with that question, and that the relevant paragraph is at 49. D334. This does look expressly at the question of scope. It says this: whilst of course we accept the scope of purpose of a Middleton inquest, that being an inquest in which the enhanced investigative obligation under Article 2 is engaged, is wider than that of a Jameson inquest. And we know that Lord Browning-Hurst referred to the severe circumscription of the verdict and findings in the latter. We reject the suggestion that the scope, even in a Jameson inquest, is especially narrow. The question of how the deceased came by his death is clearly wider than merely finding the medical cause of death. The coroner is required to inquire into acts and omissions which are directly responsible for the death, and that goes back to the case of Homburg, which is now reflected in Form 2. There's some information about that particular form. As Baroness Hale observed in Hurst at 21, the court in Jameson did not disapprove previous statements, such as that of Lord Justice Croom Johnson in the Crown and Southwark Coroner ex parte Hicks, that the word how is wide, nor the words of Lord Lane, Lord Chief Justice in Thompson, which had been cited above, to the effect that the function of an inquest is to seek out and record as many of the facts concerning a death as the public interest requires, going back to where I started. And so, again, I think that is the passage that I wanted to draw the court's attention to. So it's that principle that the Jameson inquest does not translate into a narrow scope of inquiry. And we've come back to that overarching principle, as I would submit, that there is a duty to seek out and record as many of the facts as the public interest requires. And my submission would be that a direct cause in this context is one which makes a material contribution to death in accordance with the Tainton formulation of the of causation in the coronial context.
Do we need to look at that?
I don't think so, my lord. I don't think there's any anything between the parties in respect of that. The relevant question is encapsulated in one sentence, I think, in Tainton, which is whether on the balance of probabilities the conduct in question more than minimally, negligibly or trivially contributed to death. My lord, that is, obviously that is in the bundle.
Yes.
It's at D295, and that particular sentence is at paragraph 41, just for your note. My lord, just to conclude on the legal principles, I've touched on it already, but my submission is that the court's role in reviewing a decision on scope is the familiar one for the court exercising supervisory jurisdiction, and that the jurisdiction of the High Court is going to be exercised when the decision of the coroner is one which is unlawful, unorthodox public law principles.
You're moving on from the law.
I'm moving on from the
I see the last subparagraph in your paragraph 24 is about juries.
Yes.
That question is in play on your appeal, or not?
It's not directly in play because in the decision on the decision on permission in the judicial review proceedings was that the leave was given on that one ground only that I took you to earlier. His Honour Judge Davies, King's Counsel, and in his observations granting permission, noted that should the claimant succeed in the claimant as she then was, then the decisions on jury and others would then fall to be reviewed, because the decision on jury depends on whether there is reason to suspect that a death, or it depends in part on whether there is a reason to suspect that death resulted from the act or omission of a police officer in the purported execution of his or her duty. And so that is obviously the decision on causation, which forms the subject of these proceedings, is clearly relevant to that test also, which is a low threshold test. But it isn't something that is directly before your lordships in this appeal.
I only wondered if, for example, you come onto the question of expert evidence, which I know you do raise, that might have a slightly different feel if you were contemplating a jury or if you weren't.
It may. I would respectfully submit that, in fact, the jury would, the expert evidence would be capable of being adduced without difficulty in front of a jury or a coroner sitting alone.
Yes, I see.
Lord, with that context in mind, the appellant's case is summarised at paragraph 26 of our skeleton argument. And I hope in a helpful way. That is that there was a failure on the part of the first interested party to enforce what was a clear breach of the restraining order, either on the 7th of April or in the intervening days and weeks before Linda's death. If the appellant says the inquest were to conclude, firstly, that Mr. McMahon's acts or omissions contributed to Linda's death, and secondly, that if he had been arrested for breach of the restraining order before the 9th of May, he would not have been with Linda on that day. It would follow, in our respectful submission, that the failure to enforce that restraining order made an actual and material contribution to her death in accordance with the causation test that we just looked at. And on the information that this court has and that was before the respondent, the proposition that Mr. McMahon would not have been at the address on the 9th of May if the breach had been enforced before then cannot properly be characterised as mere speculation. And so, in that being so, in the absence of investigation into the consequences of the lack of enforcement, it was irrational to conclude that there was, at this stage, to conclude that there was no causal link between the events of the 7th of April and thereafter and Linda's death. And in essence, that further inquiry into those matters is required in order to discharge the respondent's investigative duty in the circumstances of this particular case. And I've come to the matter that your lordship raises in respect of expert evidence, which is one of the sources of information which I submit ought to be considered as part of this further investigation. But there is other information which also falls to be considered as well, not least, I've already mentioned it at least twice, I'm afraid, the disclosure of Mr. McMahon's relevant antecedent history, which, in my respectful submission, is a crucial piece of evidence when considering this issue of causation. My lord, if I could amplify that summary in submissions before you now. There are two potentially contributory elements which the appellant submits call for investigation. The first is the causative impact of the non-enforcement of the breach of restraining order before Linda's death. And secondly, the impact of his presence at Linda's flat on the night that she died. Both of those matters require further investigation before findings on causation can properly be made.
Has the coroner decided that the impact of his presence on the night she died is within scope? Is that why he's an interested party?
Yes,
So
he is to be called to give evidence. So the scope of the inquest, the focus of the inquest, my lord, is on the events of the 8th and 9th of May
Yes.
2020 in particular. Mr. McMahon's part in those events is a central one, I would submit. I don't understand there to be any controversy about that, but learned friend will no doubt correct me if I'm wrong. But Mr. McMahon is to be called to give evidence. The respondent has decided, and so that his account of the events of the 8th and 9th of May will form part of the scope of the inquest.
So it would follow from that the area of interest now is the causative impact or not of the non-enforcement of the breach of the restraining order.
My lord, yes, I recognise that the two things go together, if I can put it in that way, because the causative impact of the non-enforcement of the restraining order breach depends upon the findings of the court as to the impact of Mr. McMahon's presence at Linda's flat.
But for our purposes, if the coroner is proceeding on the basis that Mr. McMahon's presence is something to be looked at and could be relevant, then one seems to be thrown back to the question of what might or might not have been the impact of the failure to enforce the restraining order.
My lord, yes, because that, well, if I may make 2 points in response to that. One point that one matter that I wanted to address you on is the respondent's position as set out in the skeleton argument, which is that there is no evidence, I think it's the way it's put, of any, that Mr. McMahon is implicated in Linda's death. And so I wanted to come back to that,
yes,
if I may, because my submission is I would absolutely clarify that no findings have been made in respect of Mr. McMahon as to Linda's death. However, in my respectful submission, there is material which does call for investigation as to his involvement on the 8th and 9th of May.
Can I just talk around that for a moment?
Yes.
Just suppose, for the sake of argument, that Mr. McMahon did absolutely nothing wrong, and suppose that the two of them got very drunk together, and that Linda's fall was attributable to her getting very drunk together with Mr. McMahon. Now, on that thesis, that hypothesis, it would still be the case that Mr. McMahon's presence had contributed to the fall, but he wouldn't have been doing anything wrong. Supposing that a jury thought, or the coroner thought, that that were the case, would one then be interested in why Mr. McMahon had been there, in the sense of why the restraining order hadn't been enforced, or would that not matter?
I think it comes back to the causative impact of his presence, and that requires consideration of the role that was played by him. And so I think it would depend on the factual findings as to what had happened. It requires that is in my respectful submission, at the centre of the inquest, what happened on the 9th of May. But clearly, the primary submission that I make is that the causative relevance of the breach of the restraining order comes into play if there is some element of responsibility of whatever type in respect of Linda's death. But it,
So it's not a sort of but-for case. You're not arguing, or it wouldn't be right for the coroner to be looking at a line of causation along the lines of but for the police's failure on the 7th of April, he wouldn't have been there in the first place, because that wouldn't really be enough to establish causation of death in the relevant Delalio sense. But if you were in a world where there was culpability on his part that evening, so for example, because he'd assaulted her in various ways, and that was thought in some way to have contributed to why she was hanging out of the window and why she fell, then it would all track back together as a single piece. Is that along the lines of your argument?
it is. The submission that I would respond to that in this way, which is that consideration of what happened on that night would have to be in the context of the history of domestic abuse which was known about, and also considering so that, and not just necessarily limited to physical assault, for example, because there may be questions of coercive and controlling behaviour, for example, which would fall to be examined. So I wouldn't constrain it. I would submit that it would have to be approached in that proper context. But yes, essentially my submission is that the question is, did the failure to enforce the restraining order mean that somebody who played a part or potentially played a part in Linda's death was not removed from the scenario before the 9th?
Yeah.
Can I assist you further on that point, Lady? Going back to the breach of the restraining order, the relevant information before the court is that, as follows in my submission: the existence of the restraining order should have been well known to Merseyside Police, and indeed it was clear from PC Wood's use of police statements by mid-April of 2020. In my submission, it's beyond dispute that Mr. McMahon should have been arrested for breach of that restraining order on the 7th of April. When that breach was later recognised, the police officer was advised that the information that he became aware of should be recorded and investigated as a crime. And as to the consequences of their recognition of the breach of the restraining order, in my submission there would have been overwhelming evidence of breach in the form of statements from the 4 police officers alone. Lord, the appellant is unaware of any factor militating against prosecution in those circumstances. And the information before the court suggests that a prosecution would have been the appropriate course.
Well, we have the code for Crown prosecutors, which tells the prosecutor how to proceed in
Lord, yes.
circumstances where there is a realistic prospect of conviction.
My Lord, yes, and associated guidance which deals in particular with certain types of offences, including offences involving domestic abuse, for example. And if I may say so respectfully, that is part of the information, again, which the appellant submits ought to have formed part of consideration by the respondent when investigating the question of causation. So that is information, those sorts of guidelines, code for Crown prosecutors, any relevant guidance, whether locally or nationally, in respect of the prosecution of offences of this type. That is information which ought to be considered before a decision on the causative relevance of the non-enforcement of the restraining order is reached, and that is information which has not been considered by the respondent or the court. And to add to that, if I may, my lord, there have been extracts of the interested parties' domestic abuse policy disclosed in the inquest proceedings. My lords, I don't know if you've had the opportunity to look at that. Those, I suspect, not. And they are in the supplementary bundle. I don't know if there are no tabs on that.
We do have tabs on that, at least I do.
It's tab 20.
Statement peacefully read.
So it's tab 20, it's page 154.
Ooh. My I can find it. It might just take me a bit of time to get there.
I'm so sorry.
The electronic numbering doesn't seem to bear any relation to.
Is it the last 2 pages of the supplemental bundle?
It is, my lord, and that would probably have been a more helpful way of directing.
I did read this, but I wasn't entirely clear what it was because it doesn't say on
Lord,
it.
no, it is. So within the inquest proceedings, there have been limited disclosure, but these are extracts of, as I understand it, of the interested parties' domestic abuse policy, so the Merseyside Police domestic abuse policy.
Sorry, I think it was all my mistake. So give me the pages again.
It's 154 of 155.
My mistake.
The purpose of drawing this to your lordship's attention and to my lady's attention is that there is a policy, it appears, of proactive policing of breaches.
Of bail
Of bail, yes.
or orders. We seem to deal with both here.
Yes. So the domestic abuse policy towards the bottom of that page 154, Lord. 6.11, and my apologies. I am in some difficulty in explaining this in the clarity that I would hope, but because this is an extract, obviously, of a wider policy, and so these are, as I understand it, said to be the relevant extracts as far as Merseyside Police are concerned in relation to Linda's case. But there appears to be a policy of proactive policing of breaches. That includes, as your lordship says, bail conditions or compliance with bail condition, but it also applies 6.11.2 to other types of orders, including restraining orders. And then, while your lordships have this document to hand, may I draw your attention to 6.11.6, which says breach of bail conditions and orders is always serious, even where the victim has participated in encouraged or initiated contact. The victim may be acting under the influence of coercive control. It's the responsibility of the defendant to abide by the conditions or order. And it's important to remember that breaches also show a disregard for the police and court orders. So again, I'd make 2 points in respect of that. One is that this is again an indication that there is relevant policy and guidance which ought to be considered when, in order for a lawful decision on causative relevance of the lack of enforcement of the restraining order to be determined. But also that in terms of providing a foundation for further investigation, this is also relevant because it indicates the likely course, or what would be expected to be the course taken by the prosecutorial authorities in case of a breach of restraining order or an allegation of breach.
I mean, as you say, there wouldn't seem to be that much room for debate about breach.
No. I respectfully agree with that. There is also evidence before the court of which provides a foundation for exploration of whether a conclusion could be reached on the balance of probabilities that, had the prosecution been pursued at the point where the breach ought to have been discovered, that would have resulted in custodial disposal. And may I emphasise that the appellant does not seek and hasn't sought in these proceedings to invite the court or the respondent to reach a conclusion at this stage that, on the balance of probabilities, had this breach been enforced on the 7th of April or thereafter, on the balance of probabilities, Mr. McMahon would have been in custody on the 9th of May. But we say that's the very thing that has to be investigated by the respondent, and that that has to be done on the basis of all relevant information. And the information here is relevant to whether that threshold is capable of being met, because there is information here which tends to point towards a custodial sentence, and that, in my respectful submission, needs to be looked at in the round with the benefit of all appropriate information in order for a lawful decision on causation to be made. And that can't be done it was premature, and it was to make the decision when the decision was made, and it wasn't a decision, it was a decision which failed to take account of relevant information, and that includes, I'm afraid to go back to it, the antecedent information in respect of Mr. McMahon, but also this sort of information about the relevant guidelines and policy which would have pertained to such a prosecution, and also the potential outcomes which are set out in guidance, including, for example, the relevant sentencing guideline.
So I've just, we looked at the coroner's directions.
Yes.
Is it, and the focus of your case at first instance and indeed on appeal and everything in ground one of your claim form was about prematurity and irrationality?
Yes.
So is that to say that the one thing that the coroner couldn't say at that stage was that there was no causal link
Yes.
established? It was certainly, it begged that begged the question, the very question in the inquest, which is whether there was a causal link established.
Yes.
So that's really the height of it, is it? That you would then go on to say, when he came to look at scope, that he got his scope question wrong because he hadn't taken account of an important factor. Is that right? So you're not saying that he got it, you're not saying there was sufficient evidence either way before the coroner. It was wrong of him to rule it out and to say, on the evidence I've got, there is no causation established.
There is no causation established. Yes, my lady. And then in the High Court is on a Judge Sefton, King's Counsel, said that essentially that it is not capable of being established.
He went much further. He said not just on the basis of what was before the coroner. Because the coroner said on the basis of what's before me, there's no causation, and you challenge that, and I understand that. Judge Sefton went further. He said, nor could there ever be.
Yes. And my submission is that that is wrong in law, and that is an irrational conclusion, if I let's put it in that way. And part of the way that I seek to establish that submission is to refer to this relevant information, which has not, in my respectful submission, been fully considered, either by the respondent or by the High Court, i.e. information about the police and prosecutorial policy in respect of this kind of breach, the likelihood of prosecution given the state of the evidence as it would have been, the offending history, or what is known, the offending history that is known about is relevant, but that had to be considered in its entirety, because it may well, depending on what is on that, is in that record, that may militate, or that may assist, or it could be capable of establishing that causative link on the balance of probabilities, because that may be highly relevant to the likely disposal of a prosecution. Also relevant is the sentencing guideline, which failed to be taken into account. That was His Honour Judge Davies, King's Counsel, granting permission, made reference to the sentencing guidelines. In doing so, his view was that this would have been a case which would result in a sentencing range of a low-level community order to a year in custody. But again, that is a question which would have to be considered on the basis of all of the relevant information, which includes the antecedent history. And I would note, in respect to the sentencing guideline, that it specifically enjoins the sentencer to take care not to underestimate the harm which may be present in a breach which is committed in the context of a background of domestic abuse. So again, this goes back to the contextual analysis, which in my respectful submission has not and needs to be done before a proper decision on causation can be reached.
And so I'm clear what you're talking about here. This is Judge Davies' order giving permission.
It is.
The relevant bit is 145, 146 of the core bundle, is it?
Yes, my lord. So that is the order granting permission. And your lordships can see the observations which were made by the judge, his paragraph.
It's 2D really, is it?
2D, yes. But your lordships also have in the in the authorities bundle,
Yep.
the sentencing guideline on breach of a protective order, which is at B1. So your lordship can see this is the sentencing guideline for breach of a protective order, restraining and non-molestation or molestation orders, and the way that this works is that the offence category is determined first at step one. I can see your lordship nodding.
I'm nodding because I'm listening to you. This is my lord's territory, certainly not mine.
My lord, yes. I don't want to take things back to too basic a level, but just perhaps for the benefit of it, clarifying the argument. The first step is to determine the offence category, whether it's A, B or C. The judge in granting permission considered that this would be, on the face of it, falling within offence category B, which is a deliberate breach, falling between A, the most serious, and C, the least serious. And then the question has to be, the second step is the question of level of harm. Categories 1 to 3, from very serious to little or no harm or distress. And the judge, again in granting permission, considered this would be a category 2 or 3 case. Category 2, culpability B, would be a starting point of 12 weeks custody. Category 3, culpability B, would have a starting point of a high-level community order. But as I said, I would invite your lordship's attention to the sentence above step 2 on that page, which is where a breach is committed in the context of a background of domestic abuse, the sentencer should take care not to underestimate the harm which may be present in a breach. So that contextual analysis would have been relevant upon sentencing, but it's also something that in my respectful submission would fall to be taken into account when determining whether you can reach a decision on the balance of probabilities that there was a causative link between a failure to enforce the restraining order and ultimately Linda's death on the 9th of May. So again, I don't invite your lordships to make conclusions in respect to this material, but it's to highlight that this material is available and should have fed into a proper decision on causation and ought to have been investigated further before such a decision was made.
Judge Davis thought this was a B2 or a B3, but sporting chance it's a B2, probably because of the asterisked bit at the top of page B2 there. So 12 weeks to start, and a range going up to 12 months. And then the bottom two lines on that page B2, in some cases, having considered the factors we're about to come to, it may be appropriate to move outside the identified category range. And then over the page to those factors, previous convictions, statutory aggravating factor, other aggravating factors, breach committed shortly after order made, and this order was made on the 26th of August 2019. History of disobedience to court orders were not already taken into account as previous convictions. Those would seem to be the major ones, and there does not seem to be much that we currently know of under factors reducing seriousness or reflecting personal mitigation.
Yes.
Yes.
So in addition to that guidance, which would fall to be considered in the round with all of the relevant information that would have been available to the sentencer had it proceeded in that way, these are matters which were relevant and ought to have been considered at the point of the decision on causation. And so, given all of that material, it's my submission that the proposition that if Mr. McMahon had been arrested before the 9th of May, he wouldn't have been present at the address, at Linda's address, cannot rationally be dismissed as mere speculation.
Stone, can I ask you, I should have picked this up, but was this an oral? Was it a hearing that led to these directions, or was it all done on writing?
There was a hearing, but it was the submissions. I'm very sorry, I'm just trying to think back to how much. I don't think I'd have to check, milady.
I mean, it looks like he only talks, the coroner only refers to paragraph 1's written submissions made.
Yes, if there were any oral submissions, they were very limited. It was primarily, it was a hearing, so there were written submissions made in advance of a pre-inquest review hearing. There was a hearing which was remote attendance, and essentially I would need to check my note, and perhaps my solicitors can just inquire into that while matters progress. But if there were any substantive submissions at that hearing, they were, if I recall correctly, extremely limited.
I don't think we have the written submissions, do we, that were before the coroner? 18th January 23 and 2 February 23.
Lady, those are not in the bundle. They were in the judicial review bundle,
Take that out.
and it was thought that perhaps they wouldn't, that things have moved on since then. But lady, if it would assist you, of course, those can be found and circulated.
I think I would quite like to know what was before the coroner. It may not make any difference, but just to have a complete picture, could I please have
Certainly.
those?
There were written submissions from the appellant and also from Merseyside Police. to draw those threads together, my Lord, can I just say this, that the coroner's court, like any other court, is frequently required to deal in uncertainties. And the question ultimately was whether that causative link could be established on the balance of probabilities. It's not necessary to be sure about what would have happened. We can never know what would have happened, of course, but that is the nature of the coronial inquiry very often. And so this is an exercise which, in my respectful submission, the coroner's court, the coronial investigation, is frequently called upon to undertake in considering the likely progress of enforcement, prosecution, and so forth. That is not in a special category, if I can put it in those terms. So just because this investigation would involve consideration of the likely outcome of other court proceedings does not mean that it's somehow debarred from consideration. This sort of investigation would not be usurping any function of a criminal court or seeking to reach a determination which would offend against the principle that the court cannot find criminal liability on the part of a named individual. It is looking at what would have happened on the balance of probabilities, having regard to all relevant information. Can we make a decision? Can we reach a decision that the causative link was there to that standard? And there has to be proper investigation of all relevant factors before you can properly find an answer to that question. So in my submission, this isn't in a special category because it involves considering what might have happened in a different legal process. The current position, though, is that a decision to exclude or to close off investigation into those matters has been taken without all relevant information and significantly without providing Linda's family with the opportunity to review and make submissions on that relevant information, including information such as Mr. McMahon's antecedent history, which is statutorily relevant to the question of what would have happened if that prosecution had taken place. My Lord, I'm mindful of your intervention earlier in respect of the relevance or the inquiry into the impact of Mr. McMahon's presence on the 8th and 9th of May. I said that I would come back to it because of the respondent's position in the skeleton argument, which is that there is nothing to suggest that he was implicated in Linda's death. And again, I prefaced my remarks by saying that no findings have been made in this regard, but there is evidence in my respectful submission to suggest that his actions call for investigation.
Well, they are actually going to be investigated, aren't they? Because they're in scope.
My Lord, yes, they are. The appellant, my Lord, is concerned by the suggestion by the respondent that there is no evidence to suggest any implication of the former second interested party in Linda's death. And so it's for that reason that I was...
That is to say, in his written reasons following the decision, which the judge sets out at paragraph 27 of the judgment, subparagraph 8H rather.
Lord, would you forgive me while I...
Yes, of course. Page 101 of the core bundle.
Yes, so the way... So the coroner had accepted submissions, so this sets out the respondent's response to the letter of claim in the judicial review proceedings, and the reasoning of the respondent, and again, my learned friend will no doubt assist you with this, but the reasoning of the respondent essentially was predicated on his acceptance of that series of submissions from Merseyside Police. And they included at H, as your lordships identified, the submission that it was pure speculation that the arrest of Mr McMahon on the 7th of April would have prevented his presence at the address, or prove the point that presence was in fact causative of death. And so that is the way that the reasoning was presented upon receipt of the pre-action letter.
That seems to be, I mean, is that inconsistent with making Mr McMahon an interested party and saying that presumably, therefore, his presence is going to be investigated?
Lord, in the abstract, I don't think it would be necessarily be inconsistent, because he may be there as a witness. But in the circumstances as we find them in this case, my respectful submission is that there is information, there is material which requires to be explored about the role played by Mr McMahon on the 8th and 9th of May, not least the evidence from the pathologist about the fresh injuries which were found, that Linda's fresh injuries which were not attributable in his view to the fall from height. But the reason why I took this point up, my lord, is that in the respondent's skeleton, paragraph 26, and that is page 43 of the core bundle. So paragraph 26 says this: of importance in considering scope, there is no evidence that Mr McMahon was in any way implicated in Linda's actions on the night of 8th and 9th May, and which led to her death. And so that is a matter of concern for the appellant, given the information that is before the court as to the history of domestic abuse. Firstly, the evidence as to injury from Dr. Rogers, the pathologist, secondly, and also the evidence of Linda's friends who speak to the coercive and controlling behaviour that she was subjected to, and also their evidence, and this is Mr. Larkin and Miss Elliott, that Linda had told them that she had looked for possible escape routes from Mr. McMahon, including on the balcony. That's what Mr. Larkin says. And Miss Elliott evidence that Linda told her that the drain pipe near the window in the small spare bedroom, which is the window from which she fell, was her escape route if Mr. McMahon were to come back. So,
Sorry, I missed that last bit. Spare bedroom, who did she tell that to?
Should we just identify the evidence?
certainly,
So Mr. Larkin was tab 15.
tab 15, and it's the end of that statement, my lord. So page 134 to 135.
I wish to add something.
Yes.
And the other witness was,
Where's the balcony? Is the balcony on the side you can see in the CCTV?
Yes.
Because it looks like there's a window opening there, but maybe there's the balcony too.
And then the other evidence is that of Miss Elliott, which is at page 143. It's tab 17, my lord. So the beginning of the statement is page 140.
yeah,
And then the whole of that statement is relevant in my submission, but the particular aspect to which I was just referring is at the second paragraph on page 143, which starts, Linda said that since the incident.
and then there's a reference to the drain pipe near to the window.
Lord, yes. Linda said she had an escape route if he did come back. She showed me the drain pipe near the window in the small spare room. So essentially, the submission, I don't think I need to take it much further, is that the question of whether there was Mr. McMahon's acts or omissions had a contributory effect is one, obviously, ultimately for the coronial court. That can't be dismissed as speculative, having regard to the information that's before the court. My lord, the appellant has also been concerned about the description within the respondent's skeleton argument of what is shown on the CCTV footage. And it's for that reason that this has been discussed between the parties, that it was thought appropriate for that to be sent to you, your lordships, your ladyship, so that rather than us trying to summarise or have competing summaries of that CCTV, your lordships can view it.
And I think certainly at least two of us have viewed it. I didn't myself find it all that easy to interpret, but
No.
maybe that sort of is the point. I don't know.
My lord, yes, and that in our respectful submission will call for careful examination during the course of the inquest and for consideration alongside all of the other relevant evidence about the events of that night. So evidence gathered by the police, the post-mortem evidence, the evidence of Mr. McMahon himself. And so that essentially is the submissions. Those are submissions I make as to the causation point. In terms of scope, Lord, our submissions on scope flow, we would say, inexorably from the submissions on causation.
Put it the other way around, you say the coroner's decision on scope flowed from his decision about causation,
My Lord, yes.
and you attack what he concluded as to causation.
It's relevant to say this, my lord, that scope is for the coroner, as we know, but that decision on scope has to be made at an appropriate stage in my respectful submission and on appropriate information. Your ladyship will recall the passage that we looked at in Delalio about the chain of causation and the observation that it's for the coroner conducting the inquest to decide at which point that chain of causation becomes too remote to form a proper part of the investigation. But that isn't a decision that was made in this case. The decision was there is no causation. There is no causal link, and that, in my respectful submission, was flawed for the reasons that I've been through.
If the coroner had said, let's just imagine a world where the coroner had gone through what was some of the material you've gone through today and had concluded that although there was strands of argument that might indicate a causal link, those were too remote, and the focus of the inquest should be on the events of the 8th and 9th of May. What would your argument then have been?
My argument would be that in this case, those events are part of the relevant facts, which must be fully, fairly and fearlessly investigated, and in order to discharge the coronial duty. My submission would be that they cannot properly be characterised as remote because they are relevant both in terms of timing and in terms of subject matter. So in terms of timing, this is just over a month before Linda's death. The mist breach came to light in mid-April, even closer to Linda's death, and so there is proximity in terms of time between the failures or the lack of enforcement of the breach and Linda's death. There's an ongoing series of events which were continued until, or they were ongoing at the point of Linda's death. And then in terms of the subject matter, we'd say this concerns the management by the police of a known risk of domestic abuse, of violence arising in that context, and the question of whether that also played a part in the events of the 8th and 9th of May requires to be investigated at the inquest, including because of the material that I've just taken your ladyship to. So that would be my submission had that been the decision. And so we would say that the question of whether findings of fact in relation to a material contribution to death fall to be made in respect of police acts or omissions in the present case can only be answered by further investigation into the 7th of April and the consequences thereof. I've already addressed your lordships on the public concern point or the public interest point, which is not confined in my respectful submission to deaths in custody, but has a role to play here. I've addressed you on the Article 2 point, not that this is a challenge, but that may become relevant if the proper investigation is done. And finally, I note, my Lord, that there is reliance placed by the respondent and the interested party on this court's observation in the Morahan case that an inquest is a relatively summary process and not a surrogate public inquiry. And I'd just say this, that the investigation that the appellant argues for would not offend against this principle in my submission. These are events over a relatively confined period of time. Professional witnesses who can refer to their notes and statements at the time, and it's the sort of investigation in my submission that is routinely conducted by a coroner's court.
And just exploring that for one moment. So suppose it were the case that there was at least a question mark as to Mr. McMahon's role on the night. And suppose there were good reason to suppose that had the restraining order been known about when the 4 police officers visited, Mr. McMahon would have been arrested and would have been in custody and would not have been there on the night that Linda fell. You are then thrown back, are you, in terms of investigation to an inquiry into why the restraining order wasn't known about? Is that getting more remote?
I would submit that it isn't. I mean, it's crucial to what happened on the 7th of April, and so to the extent that that can be ascertained, then it isn't too remote because it directly affects what happens on the 7th of April. My Lord, it's only at this point that I would turn to the decision of the court below, I'm afraid. Your Ladyship have our skeleton argument, which sets out what we say are the key paragraphs of reasoning within Judge Sefton's decision. And you also have our grounds of appeal. I'm looking, my Lord, at paragraph 28 of our skeleton argument.
Paragraphs 41 to 43.
I do. I don't know if it would assist your Lordship for me to read them out, or if you have them well in mind. The reasoning of the court, I would submit, is substantially contained in paragraphs 41 to 43. And in that extract, which I've set out at paragraph 28 of the submission from paragraph 47C. Those are the reasonings which, in my submission, underpin the decision made by the court below. And it's my submission, as your Lordships are aware, that there are that reasoning contains a number of errors of law, which mean that the order of the High Court must be set aside. So these are set out in paragraph 30 of our skeleton, and the first one relates to the relevance of bail. And so in our respectful submission, the court erred in concluding that it's likely that Mr. McMahon would have been released on bail if he had been arrested before 9th of May, and in relying on that conclusion in support, as we say he does, in support of the decision to dismiss the claim. My Lord, our submissions are really reduced into writing and probably most easily considered.
And you have really been over this territory, I think, already.
My Lord, I don't think I've been over this territory.
Not the detail of the bail provisions, but you have
I've
given the thrust of your argument.
I've addressed you on the material that I would submit points away from a grant of bail in this case on the substance. But in respect of the decision of the High Court, the error in my respectful submission was in relying on the statutory presumption in favour of bail, and also on the fact that Mr. McMahon was released on bail after his arrest on suspicion of murder as information which tended to suggest that he would have received bail had he been arrested before the 9th of May for breach of a restraining order. And in essence, it's our submission that that conclusion fails to grapple with the full statutory regime on bail, firstly, and secondly, doesn't justify the conclusion that the court reached for that reason.
Was he ever charged with murder?
No.
So, was there any power to remand him in custody for murder?
No. As far as I understand it, it was the alternative before the police at that point were release under investigation, which is essentially unconditional, or police bail, which is the more restrictive of the two options which were in fact available. But the essential submission is that the fact of bail after arrest for murder does not assist with the question of whether bail was likely or would have been granted if there had been an arrest before the 9th of May.
Charge, not just an arrest, a charge.
Yes.
That's what gives rise to the power to remand in custody.
Yes, arrest and charge, absolutely, my Lord. Because the two situations were not comparable. But in respect of the statutory presumption point, it is our submission effectively that it was an error to rely on that statutory presumption and apply it to these circumstances without having regard to the wider statutory regime on bail, and in particular the relevant Schedule 1 exceptions to the grant of bail, which are set out at paragraphs 35 and 36 of the skeleton argument. And also, without regard to paragraph 9 of Schedule 1, which lists a number of specific factors to which the court should have regard when taking a decision under paragraph 2, including the nature and seriousness of the offence, the probable sentence, the character antecedents, and so on. And so it's a similar point, my Lord, I accept, to the one that I was making earlier, but the context is different, because essentially my argument is that if the court below was going to rely on the likelihood of bail in support of a decision that it was not, that causative relevance was not capable of being established in these circumstances, then that could only be done if it was if that examination was conducted with regard to the whole of the statutory regime and the whole of the relevant information which would have been before the court if it was considering the issue of bail. And I know that the respondent and perhaps the interested party as well take issue with my advancing the proposition that the Schedule 1 exceptions to the grant of bail would or potentially have been applicable in this case. But in my submission, that I'm not asking the court to make a decision on what the position as far as bail would have been. I'm seeking to highlight that that sort of decision could not be made without looking at things as a whole. And your lordships have my arguments in respect of that. I don't think I need to take you through them. They're at paragraphs 31 to 41. And then I have made similar arguments, again, at some length in writing in respect of the relevance of the grant of bail to Mr. McMahon after his arrest on suspicion of murder. And his lordship has already identified that, or has asked me for my what I would say about the question of police bail. Essentially, my submission is that there is evidence or information not canvassed before the court below that tends to suggest that Mr. McMahon would not have been released on bail if he'd been arrested prior to the 9th of May. And it wasn't properly open to the court below to rely either on the statutory presumption of bail or on the release on bail after Linda's death, without ensuring that it had sufficient information to fully assess the significance of those matters and without hearing argument on those points. And the final point that I would make on bail is that the High Court, the reliance on those flawed conclusions, as I would submit that they are, on the prospect of bail and also on the prospect of a custodial sentence, which I will come to, repeat what I would respectfully submit to be the respondent's error of law in seeking to determine the causative relevance of the first interested party's actions without considering all relevant information. So it's a prematurity point or a failure to consider all relevant considerations. My Lord, the second ground of appeal, ground B, is about the likelihood of a custodial sentence. And we would respectfully submit that the court, again, erred in concluding, without the benefit of all relevant evidence, that a custodial sentence would have been no more than a possibility if Mr. McMahon had been convicted of breach of the restraining order, and in relying on that conclusion in support of the decision to dismiss the claim. And again, Lord, this is an issue which would ultimately, in my submission, require evaluation by the respondent at the conclusion of a proper investigation into these matters and into this, the causal relevance of the failure to enforce the breach of the restraining order. And so, again, I'm taken back to the matters that we went through earlier in relation to Mr. McMahon's antecedents, which would fall to be considered, and especially given that they are a statutory aggravating factor, and that there is statutory guidance about how those convictions should be used. That sort of information wasn't before the High Court, as I'm afraid I keep saying, and it should be considered as part of the evidence in the inquest before a proper conclusion on causation can be made. And so that was, in my respectful submission, error of law in the lower court. And then the final two grounds of appeal I can take together, I think. These are dealt with, my lord, my lady, at paragraphs 52 to 61 of our skeleton argument. And the two grounds, the two contentions or the two decisions that are challenged are, firstly, ground C. We would submit that the court erred in concluding that opinion evidence about the likely progress of any prosecution of Mr. McMahon following arrest would be purely speculative and of no probative value. I don't want to go over ground that we have already tread in some detail, but when assessing what conclusions can be drawn about what would have happened if the breach of the restraining order had been identified before the 9th of May. Again, I rely on the domestic abuse context and the guidance governing policing and prosecutions in this area, which fell to be considered. And we've gone to the limited extracts from the domestic abuse policy, which have been disclosed in these proceedings. And my submission is that the court's conclusion about the potential value of further evidence in that context, including expert evidence from a witness with experience of prosecuting cases of this type, is respectfully is wrong. An expert would be able to provide the court with an overview of the guidance that I keep referring your lordships to, and the relevant practice and the types of outcome which resulted. The probative effect of that evidence would be for the coroner to assess, the coroner's court to assess, but that would have to be done in conjunction with all of the other relevant information before the court. And my submission is that at this stage, or at all in fact, evidence of that type cannot properly be characterised as purely speculative, of no probative value, or as so inherently unreliable as to close off the need for investigation into this issue. The value and reliability of such evidence cannot, in my submission, be determined in the abstract. And so it is wrong in law, in my respectful submission, to find that the evidence is inherently unreliable.
conscious that there are two more parties
I
who
know.
need to have time to make submissions. I rather suspect you've got your message over.
I'm grateful. I'm grateful. Would you just forgive me a moment?
Yes.
Lord, Lady, Your Lordships, Your Ladyship, you have the submissions, and I think I've made the points that in relation to why I would submit that the ground C and D disclose errors of law. Can I just say this? My respectful submission is that it is insufficient for the court to say, as the judge does at paragraphs 42 and 46 of the judgment, that he does not believe that it is possible to obtain reliable evidence that would enable the court to be satisfied on the balance of probabilities that Mr. McMahon would have been in custody on the 9th of May if he had been arrested earlier, or simply to conclude that opinion evidence about the likely progress of the prosecution following arrest would be purely speculative and of no probative value. My submission that this proposition that such evidence is not capable of reaching that threshold of causation on the balance of probabilities was not properly open to the court on the basis of the information before him and before the judge. And as I said, the reliability and the value of such evidence cannot be determined in the abstract without proper consideration of the context and the surrounding relevant information. So in my respectful submission, those errors which are identified within the skeleton argument undermine the decision dismissing the claimant's claim, and for all of those reasons I would invite the court to allow the appeal, quash the decision notice and directions of the 15th of March, and to make a declaration that the scope of the inquest into Linda's death shall include investigation of the relevant acts and omissions of Merseyside Police from the 7th of April to the 9th of May.
Thank you very much, Mr. Mr. Brown.
My lord, can I make some preliminary observations before the short adjournment, please?
Please.
Can I deal with that last point first, because it is important? The request that you yourselves determine scope to include certain matters, respectfully, on an appeal from effectively a challenge to the coroner's decision on scope, it would be inappropriate for this court to itself to determine that matter. The appropriate course would be to remit back to the coroner for him to determine matters afresh in the light of such findings, or such the findings that this court makes on what ought properly to have been considered if it has not been considered. Points I'd like to make by way of preliminary observation, please, are one, about our role before this court. Secondly, about what the coroner has in fact decided, which we respectfully submit may cause the other arguments that have been advanced to be something of a red herring. And thirdly, in the light of instructions I've received this morning, just to give you some detail as to what the coroner had before him at the time he issued his directions notice. So, dealing first of all with our role, we don't argue for a particular outcome. We will seek to assist the court as to an understanding, if I might respectfully put it that way, of what the coroner had in mind when he made his decision, and as to certain matters relevant to the judgment of the judge below. Importantly, then, turning to what the coroner has decided, notwithstanding the points taken by my learned friend about passages in my skeleton arguments, the coroner has accepted in his decision that Mr. McMahon's presence on the 8th and the early hours of the 9th was at least potentially causative of Linda's death. And the reason I say that, my lord and my lady, is because that is perfectly clear from his decision notice. You've been taken to it, but if I can just go back, because it's important for a number of reasons. Page 230 in the core bundle, please. Lords, just to give you the sequence of events, the pre-inquest review took place on the 19th of January, and I'm told that it lasted between 10 a.m. and 11:10, so it lasted an hour and 10 minutes. And at the time of that PIRH, the coroner had available to him those first the written submissions that he identifies in paragraph 1 of the 18th of January 23 and the 6th of June 22. The PIRH then took place, and the coroner invited further submissions in writing, and they are dated 2nd of February from the family and 31st of January from the police. He then took time to consider all of the written submissions and the oral submissions at the PIRH, and then on the 15th of March he issued his decision notice, which is this document. I'll come back briefly after the short adjournment, if I may, to the positions of the IPs, but it is really important that I take the court, please, to section 6 of this document, page 232, scope. So in the first sentence, after setting out his discretion in setting the bounds of the inquiry, he goes on to say this: fairness will mean that the persons whose acts or omission may have caused or contributed to the death are advised of the situation, and the coroner must exercise discretion reasonably and fairly. And then this: for the above reasons, I directed at the PIRH that Mr. McMahon will be an IP and be called to the inquest to give oral evidence. So the coroner has effectively determined, as a preliminary matter, that Mr. McMahon's conduct is to be investigated. He has reached no conclusion, and nor could he properly reach a conclusion, as to whether, in the light of the evidence given by the pathologist who will be called to give oral evidence, and the evidence that Mr. McMahon will give, whether it can be said that Mr. McMahon's actions have contributed, in the Tainton sense, to death.
Well, I follow that. Does that mean that that last bit, which the judge quoted in paragraph 27 of his judgment from the pre-action letter, where it was said it's pure speculation that Mr. McMahon's presence was in fact causative of death, that's erroneous?
If that, certainly what the judge did was to summarise what the coroner's position was on the pre-action protocol exchange. But it's clear from the decision, and I think the way that puts it, my lord, is as matters stood at the time he made his decision in determining scope, contrary to the submissions of the family, there was then no evidence that would have demonstrated a probable basis for it being thought that Mr. McMahon had contributed. But he was by no means saying, and that question is closed. On the contrary, the question is open and will be a critical focus of the inquiry into Linda's death.
Mr. Brown, have we got the coroner's letter that the judge summarises in paragraph 27?
It was in the bundle, my lord, for the JR, but it's not before you, but it can be provided.
Yes, thank you.
And so, and to reassure, if I might respectfully do so, the family, a drill focus of the coroner at the inquest will be on Mr. McMahon's participation, if I can describe it that way, on the night of the 8th and the early hours of the 9th. And that would include asking Mr. McMahon for an explanation as to how the injuries determined by Dr. Rogers as being not caused by the fall from a height might have been caused, including issues in relation to a broken broom, in relation to the broken mop handle. So those are matters that are going to be investigated. And so if I can just finish on this before the break, please, my lords. So the question of why Mr. McMahon was there, whether he should have been there, if he shouldn't, what failures had caused him to be there when he shouldn't, are with respect a red herring. So far as a inquest in the Jameson sense as to by what means Linda came by her death. Even in an Article 2 case, there is no duty on a coroner to investigate matters that are non-causative. There's a discretion to investigate them, but there's no duty, and still less so in a Jameson inquest. The coroner's duty, which he will discharge, is to carry out a full and fearless investigation into the events on the night and in the early hours of the following morning that led to Linda's death.
Can I just understand how far that goes? So suppose, which this is not the facts, but suppose the 4 officers who attended in April had known full well about the restraining order, had known full well that in the circumstances it was their duty to arrest Mr. McMahon, but they had willfully disregarded that duty, let him go away, and suppose further that it was absolutely clear that had they arrested him, he would in fact have been incarcerated all the way through to June. Would all that have been a red herring?
Well, I think there are 2 separate points, my lord. Firstly, there's the assumption, for the purpose of the question, that there was serious culpability on the part of the police officers in failing to discharge their duty, i.e. in failing to take steps knowing of the existence of the restraining order. And that's all the more so given what they say in their statements that had they known of it, they would have arrested Mr. McMahon. That would then have opened the door potentially to arguments about state culpability, which would have opened the door to arguments about Article 2 and reason to suspect for the purpose of summoning a jury. But ultimately, the position remains the same. McMahon was at the flat and his involvement will be considered. It isn't a public inquiry, it's not a surrogate public inquiry, it's not a criminal or civil trial. And the coroner's duty is to focus on those events that were causative in the tainted sense of death. And by looking at Mr. McMahon's involvement, if any, on the night and in the early hours of the morning, that's what he will do. And the admission of the statement Rule 23 is important because the effect of the admission of statement Rule 23 is they're regarded as uncontroversial or agreed. So the evidence that Malone and Friend took you to from the statements of Nicola Elliott and Anthony Larkin will go in effectively as uncontroversial evidence. They'll be read into the record. And those matters can be put to Mr. McMahon. And subject to being able to assist the court any further, might I leave it there till
That makes sense. So 2 o'clock.
Thank you very much.